To all those people who have joined the seminar already, the webinar, welcome. We'll just wait a minute more to get people to register and then we'll begin. And yes, you will all get a copy of the recording as well as the slides for today's webinar. So I'll say that again at the end of the event, and I'm saying that now. You will all get a copy of the recording as well as the slides. Yes, it is 7:04 and I think it's time to begin. Hopefully people can join as we proceed, and the initial slides would deal with housekeeping and a couple of other issues, so there wouldn't be much that they miss. Yes, welcome everybody to this session on US visas for techies, entrepreneurs, startups, and investors. My name is Sweta Khandelwal. I'm an attorney. I'm based in the Bay Area. We practice mainly immigration law. Yes, just a quick introduction about myself. I'm an immigrant here. I came into the US on an H-4 visa. I moved to the F-1, the OPT, the H-1B, navigated my way through this complex web of US immigration laws, waited 13 years in line to get a green card, and even then kind of had some very interesting stories along the way. I actually had a sort of an incorrect determination by USCIS that I was prevented from getting a green card because I had some terrorism-related inadmissibility grounds. So obviously all that was not correct, but it was stressful to having, do all this journey. I was an attorney even back in India, where I originally am from, but I was not an immigration attorney, but I did kind of navigate this whole journey by myself. So I tell my clients that, been there, done that, but that experience definitely, gives me that empathy that I understand what my clients face when they're trying to do this, make this same journey for themselves and their families. So I have been pretty actively involved within the immigrant community as well as the immigration professionals. I've been a past chair of the Santa Clara Valley chapter of the American Immigration Lawyers Association. I have served with AILA both at the local, state, and national capacities. I've addressed several AILA conferences as a speaker. So I've not only been had the privilege to give back to the community of immigrants, but also to my own community of professional attorneys. I'm a frequent speaker at AILA events, and I do like to volunteer my time towards AILA activities. Fortunate to be recognized as a super lawyer, top 40 under 40 immigration attorneys in California, though the 40 ship has sailed. But also, I've been conferred with the Advocacy Award by AILA. So I've really been privileged to be honored by various professional associations. And also privileged to serve clients from around the world. I've had the opportunity to assist entrepreneurs, startups affiliated with with several incubators like the Y Combinator, StarX, Techstars, been a speaker at Stanford, MIT, and many other immigration forums across the Bay Area. So that's just a little bit about myself. A little housekeeping issues. This is obviously a presentation. It's not intended to give legal advice. It's for informational purposes only. And I would recommend that you do not rely upon it as an attorney-client interaction. Also, this is in a webinar format, so all attendees here are on mute. I have disabled chats among attendees just so that there is smoother, the presentation goes smoother. This webinar will be from 7 to 8, after which I will take questions. I will try and finish the presentation a bit earlier to allow more time for Q&A. I know that's really the most valuable part. I'll try and avoid taking questionnaires between the presentation and reserve them for the Q&A session, just to ensure that the presentation is more seamless, because when you're speaking and moderating at the same time, it kind of sometimes gets hard to, you get distracted with the questions and then you lose the flow, and then the session is taking on another different dimension. A request to the audience, please try and use the Q&A for questions. Again, I've disabled the chat amongst the audience, but you can probably still send me comments. But if you have any comments, use the chat feature. But if you have questions, use the Q&A feature. And it's very unlikely that I'll be able to get to all the questions. So please add your email ID with your questions so that I can at least try and get back to you individually. So that'll just help me to ensure that all questions get addressed. And again, please refrain from asking very specific fact-based questions pertaining to your case, because that's sort of not an appropriate, it's hard to address those in a forum like this. So yeah, that's about it. And I think with that, we can begin. Okay, so what's the objective for our session today? The objective is that we try and cover all that you need to know about US immigration laws as a techie, as an entrepreneur, and as an investor. So a quick reading of the statistics for the people who registered for the event gave me a sense that we have a lot of entrepreneurs in this audience. So I will try and kind of curate this more towards entrepreneurs, but essentially anybody who wants to work, live in the US will find this session useful, whether as an entrepreneur or as an employee at a startup or any other company. So we will go over the various work visas available for startup founders, their employees and families. So this will pretty much cover the whole spectrum of US immigration laws that are available for anyone to come and live and work in the US. And we will also try and address changes in law and policy that have been introduced by the Biden administration. So we do have some good news. Of course, there's a lot to be done on the immigration front. So it's unlikely that, without congressional approval, any president or administration can honestly overhaul the immigration system, but at least we have things that we can, be happy about and look forward to. The agenda. So essentially, yes, we will start. This is sort of the roadmap broadly for our evening. How do startups, hire the best and the brightest, which could obviously be even yourself. So what every techie startup, entrepreneur, investor must know about US immigration laws. What are the visa options available for foreign entrepreneurs? And also, how can US businesses hire and retain foreign-born talent? We'll talk about some hot topics in business immigration, with specific reference to what the new administration has implemented and changes. And then I'm going to open the session for Q&A. Okay, so entrepreneurs, startup, and US immigration. Just why is knowledge of US visas critical to techies, entrepreneurs, startups, and investors? At some level, I say when I give this presentation to people in the Valley, it's like preaching to the choir, right? I mean, we are all aware of the significance that US immigration has on the US economy, on the culture, social fabric of this country. This country is like, for apologies for using a cliche, but it is actually a country of immigrants. And 25% of high-tech companies founded between 1995 and 2005 had at least one immigrant founder, right? So that by itself speaks volumes. What does the agency that implements immigration laws is USCIS, United States Citizenship and Immigration Services. Now, what attitude does it have towards entrepreneurs? So most people are really surprised to know that we have no US visa, or until very recently, we did not have any immigration options that were geared directly towards entrepreneurs. There isn't a startup visa. There isn't any visa per se that actually addresses the need that entrepreneurs face when they come and when they want to come and start a company in the US or in the Valley or anywhere else. So USCIS has sort of always we've seen over the years as the administration changed, its priorities changed. We initially did see a shift in the USCIS approach towards immigrants and entrepreneurs and immigration. For example, several years ago, I think this was about 6 or 7, we had an entrepreneurs in residence program that was launched by USCIS. So essentially, what they are attempting to do is try and see how they can implement existing immigration laws in a light that favors entrepreneurs, founders, and startups. And again, with the Trump administration, this approach took a back seat, and now we are sort of again seeing it come in the forefront. Okay, what is important to remember is that because there are limited immigrant visa options available for entrepreneurs, founders, there is honestly, there is a no size fits all approach. Okay, so there isn't a spot on solution that you will find that fits your individual immigration requirements or your immigration situation. You all need to, as founders, as entrepreneurs, as techies, or anyone wanting to come here and work, you always need to structure your business plan if you're a startup, and plan ahead to see how you can navigate this immigration journey. Because typically what we see with founders and entrepreneurs is, their immigration is really the last thing that they have in mind, which honestly should be the first, because until you are able to legitimately come into the US and start working, there is no future for your startup. So this is a decision that you need to take right at the beginning, and you probably will have to navigate through several immigration options depending on the stage that your company or your startup is. So it does require structuring your business, planning ahead, and making sure that you're always ahead of the curve, because what visa option you are currently using would really depend upon the facts and circumstances of your case at that particular time. And as I mentioned, that there aren't too many standard laws, and even the way the agency interprets and applies these laws is very, very inconsistent. So there are gray areas, and to make sure that you're able to deal with this, you need to get creative. You as, you or your immigration attorney, you need to get creative. You need to explore all the available options, be proactive, and kind of think ahead, plan ahead, stay ahead of the curve, and always stay informed, of course. I mean, that's sort of, that goes for everything. So that's sort of the backdrop that I wanted to set, the background that I wanted to establish when we are talking about entrepreneurs, startup, and US immigration laws. So whether you're a techie, entrepreneur, investor, anyone, an employee looking, for opportunities, can enter the US on two types of visas. Okay, you have the non-immigrant visas for temporary visitors. For work, for reuniting with family, for travel, study, investment, or you have the immigrant visa. Immigrant is a permanent resident. It's what we commonly refer to as a green card. Okay. Again, you could do this via work, family, investment. But bottom line, there are two types of US visas: the non-immigrant or temporary visas, and the immigrant or the permanent visas. Let's take a quick bird's eye view of temporary non-immigrant visas. We will discuss each of these visas in more detail as we move along, but for now, I just want to give you a broad overview. Mainly, we'll talk about 6 or 7 categories of visas. We'll start with the most common, the first one that most people are aware of, the visitor's visa, the B1 or the B2 visa, and the visa waiver program, which is commonly referred to as the ESTA. Now, again, I'm sharing, I'll go into these in greater detail, but for now, just a quick, introduction to these. A B1, B2 visa. B1 is a visa for business. B2 is for pleasure. So for purposes of business, we talk about the B1. It is useful for investors, for entrepreneurs in the early stages of the business, when you want to come, check your options, meet investors, figure out an office space, lease, connect with potential clients and stuff like that. The limited purpose visas, there isn't much that you can do beyond what is specific, what is allowed. There is no employment. Most importantly, there is no employment in the US. You cannot work in the US. You cannot draw a salary, remuneration. Students have the F1 visa, followed by the OPT, which is the optional practical training program. It's like work and study at the same time. The OPT is a work visa incidental to your studying. It's for 12 months. It can be for an additional 24 if your field of major is STEM, which is science, technology, engineering, math. Students can work full-time, part-time, multiple jobs. There are no restrictions on salary. Investors and employees. There is an E2 visa, which is available to nationals of particular countries. You could either come as investors or even as managers of the company or as critical employees. At least 50% of the business must be owned by the treaty country. Treaty country means these are there are specific countries that are entitled or available. This visa is not available to nationals of all countries, only limited countries with whom US has a treaty. Nationals of those countries can enter the US on the visa, and the business must be controlled by treaty nationals. The L1, which is popularly called the intercompany transfer, again, it's a company, an overseas company, which is sending employees over to the US company. The two companies, the overseas and the US company, are must be set up as an affiliated business. The employee employed by the overseas business abroad must be employed for at least 1 year in the preceding 3 years. You have two types of L1 visas, the L1A, the L1B. L1A is for managers and executives. L1B is for specialized knowledge workers. Now we have the H1B that kind of, is everybody either loves it or loves to hate the H1B visa. It's the visa for professional workers. Another visa for professional workers is the TN. It is used for what we call specialized occupations. The person applying for the visa must have a bachelor's degree. And interestingly, like most people don't think of it this way, but the H1B, which, as you can see, most anti-immigrant or advocates kind of love to hate the H1B visa. It is actually the only non-immigrant visa, the only temporary visa for a US company to hire a foreign-born employee in the US. We have the TN. TN is a visa only available for nationals from Canada and Mexico, and that's granted pursuant to the NAFTA treaty that US has with these two countries. And then we'll talk about the extraordinary ability or O1 visa, which I like to refer to it as the rock star visa, which means it's available for people who can be considered as rock stars in their profession. So it could be the arts, sciences, businesses, anything, but they have to be at the top of their game, the top of their fields, and they need to meet the minimum 3 criteria prescribed by law. So that kind of quickly wraps over the 6 or 7 categories of non-immigrant visas, but now we'll discuss each of these in detail. And again, an advantage, they're obviously easier to apply. They're quick the process is relatively quick, and compared to the permanent visas, they are a lot more economical. Okay, so this is something that we would cover more in detail. It's not really a visa. It's called the International Entrepreneurs Rule or Parole, and it's back. When I say it's back, I mean it was initially introduced during the Obama administration. It was scrapped by the Trump administration, and now the Biden administration has brought this back. So we'll talk more about it, but this is one of the major changes that the new administration has introduced in terms of immigration reform. Okay, so now just a broad overview of the immigrant visas or permanent visas and green cards that we will talk about later in the presentation. 3 kinds, I've classified them into 3 categories. These are green cards. These are challenging to apply. They're time consuming. They're expensive. Broadly, you have something called the EB1. EB stands for employment based first preference. There are 3 types of EB1s. We call them as EB1A, EB1B, and EB1C. The alphabet really refers to the actual provision in the statute. The EB1A is a visa for extraordinary ability workers, a green card for extraordinary ability workers. It mirrors the requirement sort of is similar to the O1. Remember we talked about the rock star visa. So this is a rock star visa when it comes to applying for a green card. The EB1C is a green card for multinational executives and managers, which sort of mirrors the L1A that we mentioned and that we'll discuss more in detail. Then you have the EB2, which is again employment-based second preference, employment-based third preference. These are not really useful for entrepreneurs and investors, except for the EB2 national interest waiver. And again, we'll talk more about these. The EB2 is perm, and EB3, that's more for employees of startup companies. And then we have the EB5, which is the investor-based green card. So let's now do a deep dive into the commonly used visas, temporary visas that are available for entrepreneurs, for nationals, techies, startups, etc. So we first talked about the B1, right? The B1 is a visitor visa, okay? It's a temporary visitor for business. And this is, as I mentioned, it is available for limited purposes, negotiating contracts, attending meetings, conducting independent research. Now, the bottom line to get any visa is that you must demonstrate that you do not have an intent to immigrate. You do not have an intent to immigrate to the US. You have a non-immigrant intent, that is, you have a home or a place in the home country that you have no intention to abandon. You cannot be employed in the US. I mentioned that. I cannot, overemphasize upon this. And no remuneration needs, you can't draw a salary. No remuneration is to be drawn. The visa waiver is what you call the ESTA. Now, that is something that United States, depending on the country that, you are a national of, you will be eligible for it. I think at present, there are about 37 countries that can avail of a visa waiver. A B1, a visitor on a B1 can be in the United States for 6 months. There is a 90-day limit for people on ESTA. The significant difference between the two is, remember, when you enter on a B1, you can change your status to another visa category. From a B1, you could potentially change to an E2, H1, L1. But when you enter on ESTA, you cannot change your status. You have to leave the country and then re-enter on another visa. That's sort of the major difference between the two. And of course, and the fact that there's a 90-day limit for the ESTA. Both options are obviously convenient, they're economical, they're quick to process. There are great options during the early planning stages when you're setting up a business. What's not great about them is the law is surprisingly not very clear as to what are the activities that are permitted on a B1. You would think that they would be spelled out like in black and white, but like most things in immigration, they're not. So a tip, if you ever want to exactly know what does the B1 permit and what does it not, check the Foreign Affairs Manual. I mean, ideally consult an attorney, but the information is basically out there in the Foreign Affairs Manual, which gives examples of what are the activities that a person can do on a B1. And if your B1 is denied, honestly, there is no appeal against a denial. You must reapply. The student visa, the F1 or the OPT. So the F1 is actually the visa that allows you to come and study in the US. The OPT is what we call an optional practical training program, which allows students to work in a field which is incidental to their study. That's a work authorization specifically granted to students so that they can kind of, gain some experience in their area of academic study. It's available for full-time students, graduate students, undergrad, PhDs. You obviously must be a student at an accredited school. When I say accredited, it means recognized by ICE. ICE is the agency, the Customs Enforcement Agency that is responsible for the student visas and its implementation. Generally, students cannot work while they're studying, except in college. It's a 12-month work permit from all academic disciplines. And as I mentioned, if you're a STEM student, you get additional 24 months. So total, you actually have 3 years of a work permit, which is pretty awesome actually. Except that if you are enrolled in the additional 24 months for STEM, and your employer must be e-verified. That is sort of the requirement. What it takes to succeed. You are an international student. You need to be in compliance with all regulations applicable to international students, which means completing your academic program, taking the minimum number of credits per semester that are required, ensuring attendance and everything else that you need to do to be in full compliance of your F1 visa. I would stress that it's really important to go through this through reputed schools. There are a lot of educational institutions which have got into trouble for offering these programs with sort of the dedicated purpose of giving students work authorization. So just make sure that the school is accredited. Perhaps the biggest challenge is that a student cannot be out of a job for more than 90 months during the OPT period. That sort of puts you out of status. So this is really, especially during, say, the pandemic, when it was, things were like all over, a lot of students found themselves in this predicament when they were unable to find a job, and then they found themselves out of status. And when you're talking about the STEM extension, you have to timely file for it. So before the 12 months EAD is expiring, make sure that you file for the STEM extension before it expires. The OPT is honestly a great option for startups, for incubators and accelerators that are looking for talent. There is no minimum wage requirement, unlike H-1B, as long as you're in compliance with state wage laws. Students can do full-time, they can do part-time, they can do multiple jobs. And most importantly, the employer does not need to proactively file for any paperwork on behalf of the employee, at least not for the 12 months of OPT. So if an employer is able to find talent on OPT, that's awesome. What is not so great about it? If you're doing STEM, which means if you're enrolled for the additional 24 months program for STEM, there are compliance issues. It's now a little harder to run your own startup or do self-employment when you're on STEM, because you do need to show that you have a training program that is in line with the academic background for the students. So if you're self-employed, it's kind of hard to argue that you are training yourself, right? But yeah, it's possible, but it's just a challenge. Again, it's for 36 months, I'm sorry. So if you've started your company as part of STEM OPT, you obviously need to have a plan as to what do you do after that, right? It comes down to my first point that you always have a plan. You always think ahead as to how you will navigate from one visa status to other. There are some timing issues around an F1. We'll talk more about this when we talk about the H-1B. So essentially, if you are on an F1 OPT and you have to move to an H-1B after, you need to kind of, time it right to ensure that you can avail of the gap in between the two visa options. A deep dive into now the E2 visa. E2 visa is available. It's more, we like to call it as a visa for investors, so it can also be for employees. It is only available for nationals from selected countries. These are countries who are on the treaty, the list. US has to have a treaty with those countries. The E2 the person applying, the foreign national, has to develop or direct the affairs of the enterprise, and the treaty nationals must own at least 50% of the company. You can be an investor, you can be a critical employee of the company. Generally, all nationals must be from the same country, but if two nationalities are involved, then both parties must have equal ownership and control. So think of if there are, say, if there is, a German and a Polish national, they've joined together to start the company. Each of them have to have equal ownership and control, though both of them are from countries which are on the list. A quick recap on what it takes to succeed. The investment that you're making into your business, you have to show that it is at risk. When I say at risk, it means that you stand to lose that money. It's irrevocably committed to the business. The business has to be substantial, something more than a mom and pop store. It has to be something which can eat more than a marginal return. You need a great business plan. You need to showcase that the funds are all legitimate, because you will trace the source of the funds. Gifts from family members are fine. Salary that you have earned in the US is fine. So the money could have been earned anywhere, US or abroad, as long as it's legit and clean. You can showcase, you can show in loans, but the loan that you are investing, it has to be secured by a personal asset. You can't take a loan on the security of the asset of the E2 business. What is great about the E2 is, as an entrepreneur, as an investor, there is really no high threshold limit. Many people seem to be thinking that you need to invest at least $100,000 or something, but actually the law is clear. There is no minimum amount. As long as the investment amount you can establish is sufficient for the kind of business that you want to set up. You can use intangible assets if these assets are valued. And a great thing is a spouse of an E2 can obtain a work permit. What's not so great about the E2 is, eventually, if you move on to VC funding, then you obviously cannot continue to maintain a 50% ownership in the company, which again gets me back to my first point: plan ahead. So the E2 may be a great option for you to start, but as the business grows and you're looking for investment and stuff, it will be time for you to figure out a plan, a different plan than what you initially started with. There is no set minimum investment amount, which is great, but also that means there is ambiguity. You have to make an argument as to why the investment of the stipulated dollar amount that you're investing is adequate. And probably one of the biggest problems with an E2 is there is really no path towards a green card. So theoretically, an E2 investor can be in the United States forever on an E2 without really applying for a green card, because the E2 by itself doesn't give you a path. You have to, again, move to the EB5 or something else if you want permanent residence. Now we have the L1. We talked about the intra-company transfer, where you have an overseas business and you have a US business. The foreign business is set up as an affiliate of the US business. The foreign national must be employed abroad for at least 1 year in the preceding 3 years to be eligible for the L1. You can both have an owner of the business as well as an employee. And again, you can have an L1 for a new office, which is granted for a limited purpose of period of 1 year, as compared to an established office for which you get 3 years. But then when you come and set up a new office, you can, once that year is over, you can apply for an extension for 3 years. It's very important that you really meet the eligibility requirements for an L1, because they are defined by statute. The definition of an affiliated business, the employment duration, all these are key. You can't get around them. Both the foreign and the US company have to be in business. So you cannot set up a foreign entity for the sole and limited purpose of moving to the US. You can't shut down the foreign entity after you move to the US. The foreign entity must continue to remain in business. You have to document the relationship between two companies. These are all statutory documents. So the protocol is strict. And again, as I said, both companies must continue to do business in overseas and US for you to continue to be eligible for the L1. The great thing about the L1 is actually there is no minimum salary that the founder has to pay either to himself or herself or to their employees. There is no quota. There are no fixed number of visas available every year. You can have as many number of L1s can be issued. If you're a CEO, it actually gives you the flexibility to move around, spend time in the US and in the home country. And there is a path that the L1A offers to a green card, which is the EB1C, which I mentioned, and we'll talk a little more about it. It can be tough for an L1A for owners in small businesses, because it may be hard for an owner to show how are the executives and managers. So it's those requirements are they're stringent, and the agency is making it more stringent by the day. Again, the new office, particularly, I mean, it sounds like a good idea on paper, but to approve an L1 for just 1 year is pretty much nothing. I mean, think about it. I had clients who got an L1 for a new office for 1 year during COVID, and before they could blink an eye, the year was over, and there was really nothing to show for in terms of business growth and development. And even, COVID aside, by the time you will actually enter the country on the L1, 3 or 4 months of it is gone. So you're left with pretty little time to work on the business and make it ready, so as to speak, for an extension. And there is crazy amount of documentation and paperwork. We're just filing an L1, and I think we are already at 2 boxes of evidentiary documents, like the boxes in which you get printing paper. So it's crazy. Be prepared to work with your attorney for extensive documentation. Now we talk about the H-1B. As I said, it's like, what most people are aware of, what people love to hear more of, and which is something that is always in the news. H-1B is a visa for professionals. The position for which you are applying for an H-1, that must be a specialty occupation. A specialty occupation is defined in the statute. It is an occupation for which the minimum requirement must be a bachelor's degree in a specific field. Again, so foreign national must have a bachelor's degree. This is a visa which is tied to the sponsor company. So if you want to move around, the H-1 needs to be transferred. And there have been major changes in the way the H-1 has been implemented in the last 2 years. And honestly, those changes have been for the better. And we are also expecting some new changes in terms of wage rules and stuff to come in the next couple of months. The key thing of an H-1 is that you must show there is an employer-employee relationship between the US business and the beneficiary, the applicant, the foreign national. You have to show that there is adequate work or specialty occupation for the duration of the petition. Many people think that H-1 is not a good option for startups, which is really not true. We do a lot of H-1s for startups, small businesses, even for founders and entrepreneurs. I mean, what you really need is a great story. Okay, so the H-1B there are challenges to it, which we'll talk about, but it's absolutely not true that a startup cannot have a sponsor an H-1. It's relatively easier to file an H-1 transfer. What again, some people are not aware of, you can have a part-time H-1. So for instance, if you are an entrepreneur, you worked on your idea, you want to find a legitimate way to sort of, make money on your business without jeopardizing your current H-1 status, which you may have full-time working for another employer. You could have your startup petition for a part-time H-1B for yourself. Assuming that there is no conflict with your current employment agreement with your full-time employer. But this is an awesome way for entrepreneurs who have no other option to work in the US to find a legitimate way to work for their startups. It's really, and as far as a company is concerned, it's one of the best ways for any company to hire an employee regardless of their nationality. And spouses may be eligible for a work permit. I say may, which means depending on where you are in your green card process, your spouse could be eligible for a work permit. The biggest pain point with an H-1B visa is honestly the fact that there are limited number of visas available. I mean, I don't know where have they come up with that 65,000 H-1B visas available each year. There is really no math, no logic to arrive at that math, at that number. So there are limited numbers. There is an additional 20,000 H-1B visas available if you have a master's from a US university. But bottom line is every year you have more than 200,000 people applying for it. So the chances that you get through the lottery is pretty much, 1 in 3rd or whatever. So it's truly a lottery. It's hard for an entrepreneur, depending on how much stake they have in their company, it could be hard to show an employer-employee relationship. So you essentially have to demonstrate that the founder can be fired from the company, which is pretty much possible, but that's sort of an extra level that you need to go. So it's also sometimes challenging to show specialty occupation for an entrepreneur, because for a specialty occupation, it essentially means that the entrepreneur is working in a specific field, which we all know that entrepreneurs wear many hats. I mean, you could be a CTO, you could be a business development manager, you have to assume multiple roles. So sometimes that piece can be challenging, and depending on what is your educational or professional background, you need to work with your attorney to come up with the right position for which you can file. You can't file an H-1B as a CEO, for example. And there was a time that USCIS would kind of dismiss it as saying that a CEO is not a specialty occupation. So we always refrain from filing a generic position. I would do a CTO because you do need a technology background, or I would do a business role, right? Because you need to have like a marketing background to be into business development. So depending on what your academic or professional credentials are, you have to figure the right title and the right position. Again, not all spouses would be eligible for a work permit, which is the other pain point for an H-1. Now we talk about an O-1, which honestly is one of my favorite visas. The reason it's a favorite is because many times for entrepreneurs, this may be the only way out, and unfortunately, they may not be eligible. The reason being is that I don't know as I didn't cover this issue, but the minimum salary required for an H-1B is pretty high. It depends upon the location of the business, depends upon your title. So as an entrepreneur, you don't want to invest all this money in the company and then pay yourself a high salary. So the O-1 pretty much becomes the only option that you have. And as I like to call these the rock star visas. It means that you have to demonstrate that you are a rock star in your field, okay? You have attained sustained recognition. When I say sustained, I mean not like one time, not like 10 years back, you got some sort of a prize. That will not make you eligible for an O-1. You have to document that your accomplishments and recognition in your field of expertise have sort of been continuous over the period of years. The visa is actually more about the person applying than about the company. Okay, so it doesn't really matter. You can start a company and be in stealth mode, but if you have a documented level of accomplishment, you could qualify. and you must show that you are meeting at least 3 out of the possible 10 criterion listed in the regulations. I won't go into all of these right now because I think we may not get enough time for questions, but when you see the slides, you will figure out like what are the criterion that you can possibly showcase that you meet. You've got awards, you have media mentions, you are judging work of other professionals, you are publishing, you are working in a prestigious organization, you're drawing high salary. So if you're able to showcase that you meet at least 3 out of the possible 10, then you could qualify. The great thing about an O1 is, again, there's a lot of room for creative lawyering. Okay. If you look at the USCIS website, you may kind of get daunted because, as to the bar for an O1. And make no mistake, there is a high bar. The O1 is not for everybody. It is if only you can showcase accomplishment, achievement, excellence. But at the same time, it's not that only Nobel laureates or Oscar winners get O1s, okay? So there's a lot of room for creative lawyering depending on the field of expertise. I mean, we've done O1s for henna artists, okay? So tattoo artists, henna artists, Formula One engineers. I mean, there's just so much fun in preparing an O1. So that's particularly why we love it. But unfortunately, it's not for everyone. Okay, if you are able to demonstrate achievement, recognition, acclaim, excellence, then it's a great option. Now, I would like to spend a couple of minutes on the international parole. As I said, it's back, so cheers to that. This is an option which was actually designed specifically for entrepreneurs. So note, it is not a visa. It is what we call parole, which because you can't introduce a new category of visa without congressional action. So through agency, through rule modification, they've introduced this piece of rule to benefit entrepreneurs. It's actually the only option right now which is specifically geared for entrepreneurs. You don't have to demonstrate like accomplishment in your field of expertise, as long as your company, your startup, was created within the last 5 years. You can showcase public benefit, business growth, job creation. You are actively managing the business, have at least a 10% ownership interest, and are able to get $250,000 in investment from qualified US investors. You can apply for parole. Now, an interesting thing is, because the parole is such a new provision, and there is no way to premium process it, which means the government cannot process it faster if you pay them an extra fee. We don't have much precedent on it. So not too many parole applications have been adjudicated. So pretty much if you apply, you may be a guinea pig, but at the end of the day, it's a great option because it's been loosely worded. And there is a provision that if you're not able to get investment of $250K from investors, you can show alternative evidence as to why your company has great potential. So the 250K is not carved in stone. There should be room to kind of navigate around it. It's not the best option. I mean, parole is a start. It's better than nothing, but it has its problems. Okay, there is no path towards a green card. It's challenging to renew. It's not an act of Congress. It could go away. But long story short, it's better than nothing. Quickly, I'm going to spend a couple of minutes on green cards. Again, green cards are not something that entrepreneurs are immediately looking for, because I believe, that most entrepreneurs want a way to first start working, test their idea and get going. And green card may not necessarily be the best way, simply because it's harder to get through, it's more expensive, it's time consuming, but eventually if you come here, you start working on your idea, it takes off, it moves, you can leverage that success towards a green card. You have the EB1, as I talked about. The EB1A is a great option for entrepreneurs. It mirrors the O1. So again, think about rock stars in your field. And one thing that I do want to add is, even though if you read the requirements online, you may think that the O1 and the EB1 actually sound pretty much same. But in terms of applicability of the burden of proof that you need to show, it's much tougher to get an EB1A green card as compared to an O1 visa for the same kind of evidence, because what we say, the burden of proof for the green card is always higher than it is for an O1 visa. So it's pretty much possible that based on the same evidence, your O1 application is approved, but your green card EB1 is denied, or your L1A is approved, but your EB1C is denied. So that's why it kind of makes sense to not jump into a green card unless you already have an outstanding profile and you can leverage it. Because you don't have to be on an O1 to get the green card. You don't have to be on an H1 to apply for a green card. They're two independent processes. They have nothing to do with each other. It's just that on a practical sense, it may make it's better for you to come on a temporary visa and then kind of move towards a green card. The EB2 and the EB3, these are sort of the default options for green cards, particularly for companies to sponsor their employees. Problem, the wait times for Indian and Chinese nationals, if you want to apply under EB2 or 3, could be several years, could be decades. So it's not a great option for entrepreneurs and founders, also because these cannot be self-sponsored. Both the EB2 PERM and the EB3 require a test of the US labor market. What it means is you need to show that there are no qualified able workers available in the United States. And that is why this job is going to someone born outside the country. So obviously, if you're petitioning for yourself, it's hard to show that you are attempting to recruit your replacement, right? So it kind of doesn't make sense. The EB5 is a green card for investors. Again, it's a great option. It's pretty much sometimes the best option for people from India, because that may be the fastest way. Otherwise, you could be in line for decades. It's self-sponsored. It requires an investment of a minimum amount of money. It's pretty underrated, honestly, for the ease and with which a green card can be obtained. There are some challenges with it. I'm going to skip over to the EB5. I've already talked about these green cards and the issues here. I want to talk about the EB5s a bit, because currently we are in the middle of a lot of sort of upheaval when it comes to EB5s. So the minimum investment amount that you need, it had been revised upwards from 500K to $1 million. I mean, depending on the category, it was 500 and then it was increased to 900. And there was a category for 1 million, which was increased to 1.8 million. But these changes were overruled because it was held that they were not made following the actual protocol or process. So at this point, we are actually back to the original lower investment amounts, but we do anticipate that the administration will revise this investment limit. So there is a short window of time in which you can use the lesser investment threshold to get an EB5 green card. I mean, even though it's not going to be very easy, it's not going to be quick, it does require a lot of diligence, but definitely there is a window of opportunity before the investment amounts are increased that you can use the lesser investment threshold to qualify for a green card. So there are a lot of changes that the EB5 program is facing. Some hot topics that I wanted to cover. We talked about the entrepreneur's parole. Some good changes are the administration has reversed some of the changes that the Trump administration had implemented in the sense that the public charge memo was reversed, travel bans went away. I mean, today, November 8th is the first day that we actually officially have a policy where, as long as you're vaccinated, you can enter the US. The Be American, Buy American order that was passed by President Trump has gone away. So there have been some good stuff as far as immigration is concerned. There's a lot that needs to be done, but this is a beginning. Again, always have legal counsel. Honestly, I can't really overemphasize upon this. Immigration laws are complex. I mean, your stay here, your livelihood here depends on it. So hire counsel, have a plan, whether, especially for companies, better site visits, in case you have a USCIS officer coming in for a site visit. What's your plan? Better I-9 compliance, and and yes, I mean, remember, I know Canada is wooing all of you, but that's not an option. So yes, I'm now going to open the floor for questions. Let's see, what do we have? Again, as I mentioned, people will get a recording of this session. I will send out a recording of the session. I will also send out the slides. So do look out in the email, in your emails, you will have access to all of those. We have created a special code for attendees, not just attendees, but even registrants to schedule a consultation with me one-on-one if you find that your individual questions were not answered. So all those will follow your email. One question, what is the difference between OPT and STEM? Now, OPT is sort of the generic, it's called the optional practical training, which, as I said, is something that every student who's completed a bachelor's degree, undergrad degree, or postgraduate degree will get 12 months of work authorization to work in their field related to to your academic program, right? So it's not for you to work in a gas station or drive Uber or do all of it. It's for you to get training in your field of expertise. STEM stands for science, technology, engineering, and math. Okay, so if you are a major in one of these fields, you have an additional 24 months of work authorization. So only majors, and there are some complex rules around it in terms of, you only get it. STEM is available when you are going for a higher level of education. So you can't keep doing multiple bachelor's degrees or multiple, things. Only when you move on from from an undergrad to a bachelor's degree, or a bachelor's to a postgrad degree. But essentially, that's the difference. STEM is not available for everyone. It's only available to those students who are enrolled in the STEM field. I hope I answered that question. I'm going to read out the question as well. I'm not going to give names. It says, I'm from Bangladesh. I have a startup company. My two co-founders live in the US. Some new investors interested in funding for a startup. How can I visit USA? What is a better visa category for me? Again, it depends on what you want to do. Okay, so if you want to come here just to meet the investors, to meet your co-founders, to arrange business meetings and stuff, you can do that under the B1 visa. The B1 would be you're from Bangladesh, so ESTA would not be an option for you. And the B1 has the maximum duration that you could be here is generally 6 months. But again, remember, you can't make it a habit by coming to the US and staying for 6 months and going back and again coming back for 6 months. That's sort of something that will get you trouble at the border. So depending on what your purpose is, if you want to come here and sit and work, draw a remuneration salary, then likely we'll have to figure something else out. I don't believe, I need to check whether Bangladesh US has a treaty with Bangladesh. I could do that right now. If it does, then you could do the E, but otherwise, the B is a great option to start with, and you can take it from there. I hope that answered your question. I'm a startup and I've invested a bit of money. If a US VC is investing and I want to move to the US, what are the requirements? Is it possible to visit US to explore possibilities for the purposes of business? Okay, again, as I said, B1 is a great visa for you to come explore possibilities of business, meet with investors, meet with clients, conduct meetings, do some independent research. Perfect. If you have a US, so you could probably come here and meet the VC and stuff. If the VC wants to invest and actually does make an investment, in that case, maybe the entrepreneur's parole is a great option for you, depending on how much money the VC is investing. But remember, for entrepreneur's parole, your company has to be incorporated in the US. Okay, if your startup is based in India, then honestly, a US visa is not really a relevant question. You need a US visa when you're living here, working here, making money here, okay, not otherwise. I'm a founder here in India. I like to come to the US to explore the opportunities to raise capital, work with probable collaborators. I've already been funded. Possible to move to US if a US based wish to invest money in a startup. Okay, so again, I'm getting a lot of interestingly B visa questions, which is usually not what I expect. But again, you can come on a B1, explore the possibility to collaborate with potential investors or partners or what you may. If you are able to raise money from the US, we could do entrepreneur's parole. Since you already have a company in India, you could set up an affiliate company in the US and then move on an L1. Again, that depends upon what's the size of the company in India. How many employees, I'm not sure if I mentioned, but the key thing for a founder to come here in the US is the founder can either come on an L1, is that the founder can either come in the US on as an executive or as a manager. So you have, for either one of which to happen, you have to have employees in the US, in India, or the overseas company. So if you have employees overseas, you're supervising, managing them, then the L1 is a great option to come. Since you're from India, obviously the E is not an option. And remember, depending on what's the success story that we can craft, the O could be an option. How do you demonstrate that you can meet the O1 visa for being a rock star in business? Now, as I said, the criterion is, there are about 10 criterions listed in the regulations. You need to demonstrate that you meet at least 3 out of 10. When you say in business, sometimes one way that we make this argument more plausible is we define your field of expertise narrowly. So for example, it's kind of an idiotic argument to make that so-and-so is one of the best software engineers in the world. I mean, that doesn't sound, it's hard to prove, if anything else. So the way we do it is we really narrow your field of expertise. So we can say so-and-so is a great, say, data providence engineer. Okay. So by narrowing your field of expertise, it's much easier to kind of elevate your profile. So even when you say business, sometimes we can narrow it to the area of business. I mean, we do a lot of techs and high tech and stuff. So even if someone is demonstrating extraordinary ability in business, We can also limit it further by saying, okay, this is a business in the cloud space, or this is a business in the healthcare or the biotech, So by limiting, by defining the field of expertise narrowly, you are elevating your profile. Okay. So again, if you show that you have won awards, you have judged other professionals' work, if you're employed in a company in a critical or an essential capacity, your salary is much higher than what other people in the field are getting. So these are the ways that you can showcase, and you have to show at least 3 out of the possible 10 that you are a rock star. And I mean, the word rock star is more the way I like to use it. You won't find that in the regulations. What about spouses on H4 visa, but without an EAD starting a company? I am so sorry, you are really out of luck. I wouldn't recommend doing anything without an EAD, because you will be actively managing the company. It's hard to argue that you've started a company and you're doing nothing with it, right? So starting a company means you're an owner, manager, you are involved in it in some capacity. So without an EAD is not something that we would recommend. Okay, that's an interesting question. Have you ever seen an L1A being granted to a petitioner who would be working from home in the US to an employer that is already established in the USA, as opposed to opening a new office? So remember, one thing which is interesting is, and the reason I said that's an interesting question is because it hits directly at the L1 requirements that are built into the statute, which is that the L1 requires that the US company have a physical office. Okay, I know it may sound like really retarded, honestly, in today's day and age, when everybody's working out of home and there is no need for a brick and mortar office and all of it. But this is a requirement that is codified. It's built into the law. So even if you have an employee who is here in the US and maybe working out of home, we do tell our clients that have a physical office, have a lease agreement. It's not possible to get an L1A without one. And if you go back to my slides, you will see a specific reference that you need to critically adhere to the L1 requirements. And some of these requirements don't even make sense in today's day and age, but unfortunately we have an agency which hasn't moved with the times. The laws haven't changed with the times, so they would still implement that. Okay, from all of the available US visas, what is the best, fastest and cheapest way to get to be a US resident citizenship with the least burden? Okay, that's like, if I knew that, I would be a millionaire. Okay, the answer to your question is marry a US citizen. Okay, but honestly, jokes apart, I think that's one of the most expensive ways of doing it. That's not going to be a free lunch. So I mean, think of it, there are basically 3 ways you can move to the US. You either have an employer who sponsors you, you have a family member who's a US resident or a green card holder who sponsors you, or you are an investor who comes and invests money in the US. These are 3 broad categories. In employment, you will always need an employer unless you can do a national interest waiver EB2, which can be self-sponsored, again, or an EB1. Now, these are high bars, okay? Not everybody can file an EB1A, which is like the rockstar green card. Even an EB2 national interest waiver requires you to demonstrate a very accomplished professional profile, as well as requires you to showcase where you are, how you are making a difference to the interests of the US. And the EB2s and the EB3 green cards, and again, you can go back into the slides, they have a lower bar, but again, depending on, you need a job offer, you need an employer. And the most important piece here is, it's an anonymous attendee who's asking this question. I don't know where are you from. So your country of birth, not nationality, mind you, really determines your place in line. So for example, people born in India or China are taking 30, 40, 50 years potentially to get a green card under EB2 or 3. Whereas if you're not born in India or China, you could possibly have a green card within a year or two, right? So depending on how fast it's processed. So my suggestion of marrying a US citizen, honestly, as long as, and I have to say this because as long as there is no fraud, you are in a genuine relationship, you are sort of intending to be with the person, that's pretty much the fastest way to become a US resident. The EB5, can you please talk more about EB5? I would love to talk more about the EB5. Unfortunately, the EB5 is something that I can talk about it for the whole day and it'll still not be enough. I would give you some quick tips. Do look at the USCIS website. It has a lot of good information about the EB5. Okay, you can reach out to us always on EB5s. I mean, I've presented at EB5 seminars in the Bay Area, in India, across India, and we can definitely assist you and guide you with it. But at this point, the EB5 is also at a very precarious position as far as the program itself is concerned. Parts of the program, like the pilot program, the regional center program, which allowed for lesser investment of money, that plan has lapsed. Congress has not authorized it and not extended it. So at this point, those are in limbo. So hopefully they will come back with it soon. But yes, there are some options, and I could definitely advise you or guide you on it and even provide you with more resources. But please reach out to me outside the session, and I'll like to help you. But for now, go to the USCIS website that has a surprising amount of information which people often ignore. Okay. If I get sponsored for an H-1B from a company, do I have a lower chance of getting it if my bachelor's was in a different degree? This is a hard question to answer. It's an important question. It's a relevant question, but it's hard to answer. The answer is it depends. I mean, you have to have it in, like, you cannot get an H-1B as an accountant if your degree is in engineering, okay? But there are cases you don't have to have a degree in computer science to get an H-1B as a computer engineer, okay? For example, you can have an electrical engineering degree and still get an H-1B in a computer science. So it really depends on what your facts are, but it can't be totally unrelated. I hope I was able to address that question. A legal cost that an entrepreneur should expect when wanting to move the business to the US. I mean, honestly, it could really be all over the place, depending on which attorney is scamming you. That was a joke, sorry, a bad one. But yes, don't go to notarios. I mean, go to a licensed professional attorney. And even here, there are two aspects of your question. If you're talking about moving the business to the US, that's really not an immigration question. That's a question for a corporate lawyer, but it's only when you decide to work in the US after you have incorporated a company that you go to an immigration attorney. Okay. In terms of cost, again, it's a huge spectrum. It really depends upon what the attorney is charging. The government fees, obviously, USCIS fee would be the constant. But if you're simply moving the business, that's more a question for a corporate lawyer to answer than an immigration one. As a Canadian startup founder, can I create a US-based subsidiary and be eligible for a TN visa? Honestly, that'll be hard because, again, the TN cannot be used for self-employment. Okay, the TN. There are some ways that you could possibly see how you can do it. Maybe, put yourself on the payroll of your company, come as a management consultant and stuff, but that does need some wriggle room and some creativity. But generally, you can't you could create a company, be an employee of the company, and offer professional services to other company. But can you just sponsor yourself as a CEO? No. Hope that was helpful. Where can I find more information on H-1B part-time? Send me an email. It's there in the regulations. You can, if you're able to navigate through the statute, it's there. But otherwise, long story short, you can work on an H-1B. You can have, one full-time H-1, one part-time H-1. You could possibly have two part-time H-1s. There is no law which says you cannot have this or you can. There's again ambiguity there. But practically speaking, we can't do two full-time H-1s. It's hard to make an argument that someone is working 80 hours a week. So generally the way you do it is 30 plus 30 or 40 plus 20. That's sort of the rate. Anything which is more than 30 hours a week is considered full-time. Common path for foreign entrepreneurs to get a green card eventually. It's a very deep and profound question. The answer is actually nothing. Okay. And there are different paths, which is why I come back to point one. You need to constantly change your immigration strategy, your plan. You may start with one visa, end with another. For example, you may come on an E2, okay? Eventually you get funded. You may have to move to the parole. Your company gets acquired and there's a lot of publicity and media coverage. You may figure out the O1 is better. Then, but a direct path for a green card is something that is not available for entrepreneurs. You could do an EB1. You could do a national interest waiver, which is a generic, that's a generic option if for anybody who meets those criteria, but it's not an option specifically created for entrepreneurs. The only option that allows entrepreneurs to work on their startups, on their ideas, is actually the entrepreneur's parole. General recommendations for Canadian entrepreneurs and corporate professionals. The E is a great option. You want to start your business. TN, I understand, is limited in its applicability, but the E1, E2, the treaty trader, treaty investor is a great option. EB5 is a great option for anybody if you can. And remember, there are sort of creative ways to do it. Let's say you start with the E and you continue to invest the money that you've generated from the business back into the business. Eventually, you will be able to show that you have invested a total of 1 million or 1.8 million, whatever the threshold amount is, and you can qualify for the EB5 green card. So it's not that 1.8 million has to come out of your pocket right now. You start your business on the E, you keep reinvesting the business revenue back into the business, eventually grow that investment to what it takes to get the EB5. Again, come back to the first point. It's a continuous evolving strategy. Another good question, does experience in the field stand for formal education? Yes, depends again, what visa are you applying for? If you're applying for an H-1B and you need to show a bachelor's degree, every 3 years of experience on the field is the equivalent of 1 year of education. So for a 4-year bachelor's, which is what you need to do for an H-1B, you need to show 12 years of education, 12 years of experience. That can be evaluated to a bachelor's degree. Some visas like the L1 or the O1 actually don't require a bachelor's degree. I have lots of entrepreneurs. It's cool for entrepreneurs to be Harvard dropouts and Stanford dropouts and all those stuff. So a lot of them who dropped out of college, they actually can't do the H1 if they haven't got the required level of experience. So we go with the O1s or because there is technically no requirement that you have to have a bachelor's degree in your field. It's only for the H1 and the TN. Is it harder to apply for a visa if I'm outside the US? I've never, I mean, it depends on what visa you're applying for. If you're applying for the B1, you do apply for it outside the US. If you're applying for an H1 and stuff, practically it makes more sense to be here because you're going to be able to scout the job market here and stuff better, but not really. I mean, theoretically speaking, purely from an application of the law, you could do an EB1A based out of your home country, self-sponsored EB1A, national interest waiver, or E2. All these visas, you don't have to be in the US. If you are the one who's driving the investment, if it's self-sponsored, if it's something, your efforts are what are responsible, you don't have to be in the US. You can apply for it from wherever you are. It's just that when you are doing an employer-sponsored option, you know, just in practical terms, you don't have to be here, but it's easier that way. These employers are also more keen to hire people who are here than opposed to outside. I'm just going to mark these as answered because I haven't done that. That's showing a lot many open questions. Give me a second. Just from housekeeping purposes. Okay. If I was in the US with an L1A visa, after how many years can I apply for a green card? You don't have to, you don't even have to be in the US to apply for an EB1C green card, if that is what you're asking. Remember that non-immigrant visas and the immigrant visas are independent, they're separate. They technically have nothing to do with each other. You could always apply for a green card without ever applying for a non-immigrant visa. It's just that in practical terms, I mean, people would take the first option and then move from there, right? So can it be self-sponsored? Depends what you are applying. EB1A can be, EB2 national interest waiver can be, the others can't. If I have a master's degree in one field, but I get sponsored for an H1B for a different field, am I eligible for the extra 20,000 slots for the H1B? I don't believe you are. I think for a master's degree, you have to have it in your field of expertise. Can I work for my startup while on H4 EAD, provided I get a board who has the authority to fire me? I think there is a confusion here. If you're on H4 EAD, you are your boss. You can work for your own startup. You don't have to have a board. You don't have to have anybody. You can do whatever you want if you have the EAD. The problem is if you don't have the EAD. So the board and stuff is only if you're on an H1B and you want to work for your own startup. How to apply for a part-time H1B? I mean, it's not a separate application really. I'm not sure who's the one who's sponsoring it. It's hard to answer this question based on what facts I have. It's just like, it's like any other H1B application. You just have to choose the part-time option. You have to specify the number of hours that you will work, you know, as part of the part-time. How might that affect the chance or application of an EB2? I'm already at 8:30. I'm going to take questions for 10 more minutes and I'm going to try to go faster. How might that affect the chance or it won't impact your green card? Are there any age limitations to any of these visa categories? A very interesting question. Not really. I mean, there are age limits that matter. I mean, in terms of how you define child and adult, a child in immigration, but otherwise, generally, for any of the stuff that I've talked about, the age is not a barrier. Can I change my My company is in Jordan, investing to open a factory in the USA. I'm now in US under B1 since 3 months. Can I extend? You can extend your B1 visa for another 6 months. It's possible. There are some practical limitations that are coming more because of the time that the government is taking to process these applications. So you may want to extend it for 6 months, but USCIS is taking 9 months to approve your application. So it's honestly, I mean, COVID has created a nightmare when it comes to immigration adjudicating USCIS adjudicating these applications. So I don't want to get too much more into details because I don't want to mislead you. You can theoretically, but then reach out to me to discuss what your situation is. Do the different types of visas require you to stay a certain amount of time in the year in the US? Like many L1s, O1s, you can keep shuttling. Generally, the implication for an H1 is that you are employed by a US employer. So you're expected to stay here in the country. If I apply for the O1 and get rejected, can I apply again later? Absolutely. I mean, there's nothing that prevents you from applying again. It's not a black mark. You don't become, you're not like in some, I mean, there is no special file that is created for you because you got rejected. You applied for a benefit, they did not approve it. You can apply for it again and it may get approved. So please do not think that you do not, don't fear a denial or a, when you're considering these options. It really doesn't matter. You can be denied for one and approved for another and vice versa. I have some questions on which I don't think are relevant. I'm not going to get into those. How long would it take to set up an affiliate company and then get, I mean, setting up a company is not really, again, that's more of a corporate, a job of a corporate lawyer, but it's not, and also depends on which state and all of it. Most people incorporate in Delaware, and then if you're in California, then you will have to, set your business as a foreign company in California. I have some questions on, can you be the owner of the affiliate? I would say that the definition of an affiliate is a statutory definition. So do reach out to me. I don't want to go into it at this time because we don't have that level of that much of time. But there are 3 ways that you can, a company can call itself as an affiliate. So that's defined in statute. If I take a significant pay cut compared to my current job to be part of I mean, these are questions which are honestly ambiguous. It's a gray area of the law, okay? If a company is giving you a bare, and I would say it's a misrepresentation. Your transfer may still get approved, but there are potential problems that you could face later on. Because if a startup is just paying you the minimum amount, the H-1B, that's what makes the H-1B honestly such a painful visa. Because the H-1B says that the minimum salary requirement is a guaranteed minimum. Does not take into account stock options, bonus, all that stuff, or incentives. So when you say that I'm being paid, say a minimum amount of 60K, it doesn't, you are making, when I say you, I mean the company is misrepresenting to the Department of Labor. Because how can you pay a salary for a senior level, I'm assuming you're not an entry level employee, is 120K. So you are not, the company is not in compliance with the wage rules. I will share the slides. I will share the recordings. Investing money through startup qualify me for work. invested money would be through a venture capitalist. I mean, again, look at the entrepreneur's parole. That parole means you are qualified to work here. You are qualified to work only for your startup, okay? Not for anybody else. Does it mean that an EB1 does not need a US sponsor? EB1A can be self-sponsored, not other categories. Unfortunately, none of you have written your emails here. If I had emails, I could have attempted to respond to your questions. I'm in the US on an L1A visa. Can I switch to an H1B? You can, but you will have to go through the H1B lottery. After how many years can I apply for a green card? Green card meaning who is applying? Is it the employer? Is it you? The employer can sponsor you anytime. Can you self-sponsor it? It depends. You can self-sponsor an EB1A or a national interest waiver. You cannot self-sponsor the EB2 or the EB3. How does registering your company in the US help a startup to file for immigration? I mean, honestly, registering doesn't necessarily have anything to do with immigration. It's just that let's say, sometimes you want, even for an O1, you can't self-petition an O1. You can self-sponsor, but you can't self-petition. There is a difference. So if you want to start your company on an O1, the company will petition for the O1, even though you may be the only shareholder in the company. I hope it makes sense. I mean, I'm trying to address this the best way I can within the limited time. But that's why, registering your company and all of it is actually something which is within the purview of business lawyers, corporate lawyers. Immigration is only concerned with you working here, right? But in some cases, if you have a company here, it will help to incorporate. It's actually not mandatory, but it will help to incorporate your company, get an FEIN number, so that the company can then go back and do a sponsorship. So that's why it kind of helps. So I did try and address, I'm sorry, I may not have clicked on answer for these questions, but I did try and address as many as I could. To all your questions, how do you will get recordings, you will get, I will send you an email with the recording, with the slides, and with the coupon code, which will allow you to go onto my website and schedule a consultation if you want to have your questions answered. All registrants will get a 20% discount on our consultation fee. So that's great. Do check out our website, subscribe to our newsletter. I do weekly newsletters. They're lengthy articles, more than 1,200 words, and have a lot of information. Hopefully they will be you will find a lot of relevant information. And yes, thank you all for registering for this seminar. I hope you found this useful. And yes, if you have any comments, suggestions, feedback, I would love to hear from you. And definitely I would try and get this to you within the next week, with the recording as well as the slides. So do look out and keep a watchful eye for an email. Thank you. Bye-bye.